Any mention?
Please, Your Lordship. My Lord, I beg to mention item number 23.
Yes?
Item number 23, my Lord. On behalf of the state respondents.
On the main list?
My Lord, yes. My Lord, this matter was led by Mr. B. Bhattacharjee, AAG, my Lord. So, my Lord, this matter will be re-endorsed. So, my Lord, I'm praying for some time.
Okay, other requests also, after 2 weeks.
Lordship, I would like to make a mention for item number 18, Lordship. On behalf of Mr. Nair, he's not well, Lordship, so Mr. Nair, UK Nair.
No objection.
I have informed all the respondents. After 2 weeks, Lordship.
3 weeks, this matter has been adjourned all the time, yes.
Yes, Lordship. Highly obliged.
Take a longer adjournment.
Highly
Yes.
obliged, Lordship.
May I please, Lordship, I beg to make...
Yes?
Lordship, I beg to mention item number 21 as the conducting counsel Deepak had some personal difficulty.
21, which one?
Of
Varun
the
Kumar.
yes, Lordship.
For Mr. Pathak?
Yes. Yes, Lordship.
2 weeks.
May I please,
Yes.
Your Lordship, I beg to make a mention of part 2 of the hearing list, item number 24 and 25, Your Lordship. I have informed, I have taken the consent of the counsel for the petitioner. This matter may be listed after 2 weeks, Your Lordship.
Why?
Today I am not, I have some personal difficulties today, Your Lordship.
After 2 weeks.
Hello, please, Your Lordship.
May it please your Lordship. Lordship, I beg to mention item 16, my Lord. It's a joint request from the parties. Arguing counsels are not available today, Lordship. Not available today, my Lord. Senior counsel as well as Mr. Day.
2 weeks for the request of counsel for the party. Yes.
Much obliged.
Follow the list.
Lordship, I beg to mention item number 19. May this matter appear after 2 weeks.
Why?
On account of personal difficulty of the senior.
Who's the senior 19? Mr. Guru?
Yes.
No objection, Your Worship.
22 matter. Okay, 2 weeks. Yes. Yes.
Main list, item number 1. Main list, item number 1.
Yes, Mr.
In this case, I need some time to file it.
What time? Last time you were supposed to get instructions by 2 o'clock.
So
now that was on the 21st of August. So you've submitted your bid.
Lordship. Lordship, in the meanwhile, there are fresh tenders we are being floated. So, Lordship, it has to be the interim order has to be absolute so that I can participate in the fresh.
No.
Lordship, what happened is the department is issuing fresh tenders every day. So because the interim order is only till today, Lordship. So unless it's till further orders.
Yes, Mr. Adebna today submits that.
It's 1 week's time.
Yes?
1 week's.
Submits that 1 week's time is 1 week for them required to anyone to obtain instruction stuff. Accordingly, this is matter of 1 week on so and so. Interim order dated. Interim order shall continue till next date. Yes.
Till next date, Lordship.
Supplementary list, item number 1.
State not necessary party here.
Lordship.
State not necessary party
State
here.
has no role, Manoj. Whatever action has been taken only by the respondents.
Yes.
They just present the facts, Manoj. The petitioner is a member of the Garo community. She had purchased a property in the year 2016 and she started construction on that property as well, Manoj. So while the construction was going on, she had approached the MECL for an electricity connection. She was informed that she required to obtain an NOC from the Dorvashnau. So as such, she obtained an NOC from the Dorvashnau, but the Dorvashnau reclaimed it shortly thereafter. And then they sent members of the Dorvashnau to try and stop the entire construction activities in that property. So she went back to the Dorvar's office and inquired on what authority they would do such a thing. So they informed her that they did not have any NOC for a construction. She thereafter issued a letter asking her to be recognized as a member of that particular village. They issued a letter saying that she did not own any property in that particular village. She issued a legal notice, followed by 2 additional legal notices, questioning their authority to issue NOCs, but in any event, asked them for a copy of an NOC to start her construction and to continue it. So by 2018, she had completed about 80% of her construction. At that point, she was advised to file a suit for declaration. As such, she filed a suit for declaration against the respondents before the District Council Court. While it was pending, she came to learn that in view of the judgment in Kintyakar Suchiang, which holds that the District Council can only take up matters between 2 tribals, she filed an application for transfer to the competent court. While that was pending, it was taking a little bit of time because she filed the transfer application in the month of January 23. Until May, it had not progressed. So in the month of May, she filed an application for withdrawal with liberty to file afresh. As such,
she suit now.
No, that suit has been withdrawn, my lord, because suit would not be an efficacious remedy because she's completed about 80% of the entire work. Now, suit may take a very long time. It is not an efficacious remedy. As such, we are before this honorable court.
What do you want now?
The remedies, my lords, they should be stopped from demanding an NOC. That is all. That is a limited prayer, my lords. Because we've issued several letters, several legal notices. There is no response from their side. The question is, what authority do they have to interfere?
Let them appear.
Lordship.
Sir, Mr. Essendo, I'm court's highly doubtful, if you don't, there's no state respondent because not even the District Council also. Anyway, heard Mr. Essen, the council, the petitioner, issue notice, returnable in 3 weeks. petitioner to take step for issuing notice to respond within 3 days. This thereafter and so on, sir.
Very pledged.
Item number 2.
May please, Your Lordship. This is in regard to the payment of compensation manual under Electricity Act of 2003.
Compensation?
Compensation in regard to the construction of transmission line over the land of the Hima Moplang. And for the purpose of construction of transmission line.
What do you mean a compensation to payable to whom? Was the land acquired from you?
Land has not been acquired, but that has been used and construction has been done. So,
the court doesn't understand. What do you mean by land has been used and construction done? There were no acquisition proceedings.
No, there is no acquisition proceeding.
Under what law they took over the land?
Under Electricity Act 2003, my lord.
It was for transmission lines.
There is a scheme of the central government which has to be executed by the power grid for the purpose of.
Who is the petitioner?
Petitioner is the Hima chief of the Moplang Lingdoship.
Who does the land belong to?
That land has been taken from the Hima Lingdoship.
Where is that?
Right land.
Where is that? That has been taken from right land.
From the right land, my lord.
No, show which, how do you show that?
Paragraph 10, my lord.
No, from the annexures.
From the annexures, my lord, they have first annexure, my lord. That is page 64.
Yes.
Where it has been, a letter has been written to the acting king at that point of time by the manager from the power grid, stating that under the scheme of Northeastern Region Power System Improvement Project. May I read your?
It just says that we're constructing a 220 kV DC transmission line from Killing to strengthen the so and so. In view of the above said line passing through Moplang area map and close, only NOC is required. They're not saying that it's going through your land and compensation will be awarded.
Yes, my lord, it's there. NOC is required because that transmission
at this point of time, this letter, next letter 65 is dated when? 19. This is addressed to whom?
My lord, addressed to the Lingdo, my lord. And that Deputy Commissioner also have
compensation. Yes, who's appearing for Power Grid? Oh, who's the Ministry of Power? Yes. Yes.
I am for the Union of India.
We'll issue notice then. What are your rights? But you have to establish that. I heard Mr. H.R. Nath, the Council Petitioner, issue notice. Mr. Devnath, that CGC is present, accept notice on behalf of.
Yes. Number 1.
Number 1. Who number 2? Known for the state.
2, 7, 9 and 10.
You accept notice, Mr. SN, accept notice on behalf of 2, 7, 9 and 10 and MECL. MCL is
yes. 8 and 13, my lord.
6.
This is MEPTCL.
What is that? Yes, it's part of MECL only. Yes, ARC only we have 6. Then Power Grid,
3,
response
4 and
number?
5, Your Lordship. 3, 4 and 5.
3, 4, and what about number 4?
Your Lordship, 4 is also part of the Power Grid, Your Lordship.
So 3, 4 and 5.
3, 4 and 5.
3, 4 and 5. And where is this a council?
It's in 11, my lord. 11, 12.
11, 12, you serve notice?
Yes,
notice to go to
respondent
number 13. Right, even 3 days. This matter of 3 weeks. Yes. For instructions to affidavit. I'll be blessed.
Item number 3.
Yes, Dr. Mazika.
Met with Lordship. Lordship, dal mill is before your Lordship, my lord. It's challenging certain...
This dal mill?
My lord.
Yes.
But why I'm saying so much is because some dal mein kala hole this way.
Huh? Yes.
My lord, the Directorate of Social Welfare issued a expression of interest, my lord. And we are challenging some of the clauses of this EOI, my lord, on 6 counts, my lord.
Yes.
My lord, the first clause we are challenging is Lordship will find that EOI at page 49, my lord.
Yes.
My lord, this is a tender for ready-to-eat food, micronutrient fortified energy dense food under. But this is Anganwadi program, the ICDS, the food is provided, my lord. My lord, this is a scheme under the National Food Security Act, my lord. I have annexed and I'll take a lordship to certain provisions. My lord, in clause 6, your lordship will find at page 49.
Yes.
They are asking for experience of past 3 years, my lord.
Clause 6 of page 49.
Page 49, my lord.
It says that dominant past experience
for supply of micronutrients
10 crores each.
10 crores each for 1920, 2021 and 2021-22, my lord. Now 23 has already gone, my lord. Past 3 years will include and should include 23 also, my lord. That is our. And my lord, same thing is repeated in clause 10 also, lordship will see on the next page. Same thing.
There must be a typographical error.
Either non-application of mind, my lord, or typographical error, my lord. My lord, that is my first submission, my lord. Second submission, my lord, is
3 years.
3 years, my lord.
3 years.
Should be the last 3 years in my humble submission, my lord.
Yes. Yes.
Second grievance we have, my lord, is with clause 17.
Clause 17.
Clause 17, my lord, at page 51. It says valid ISI certificate issued by the Bureau of Indian Standard.
Yes.
It is our case, my lord, there is no ISI code or ISI certification for this particular product, my lord. That is our second case.
Then you don't have it, then the other bidders won't have it also.
Others won't have it, my lord.
Then?
And if others also don't have, my lord, how they'll do the selection, my lord? That is a pertinent question, my lord.
Okay.
My lord, my third grievance, and which is the most serious grievance, is, my lord, that I'll take your lordship to the Act, my lord. National Foods Security Act, page 97, my lord.
Yes.
My lord, section 4 of this Act, my lord, it says.
Yes.
Subject to such schemes as may be framed by the central government, every pregnant woman and lactating mother shall be entitled to meal free of charge during pregnancy and 6 months after the childbirth through the local Anganwadi so as to meet the nutritional standards specified in Schedule 2.
No, you read section 4.
Section 4, my lord.
Subject to such schemes.
Such schemes as may be framed by the central government.
Okay.
Every pregnant woman and lactating mother shall be entitled to meal free of charge during pregnancy and 6 months after the childbirth through the local Anganwadi so as to meet the nutritional standards specified in Schedule 2. Schedule 2 of this Act, my lord. My lord, similar provision is there, section 5, that deals with children, my lord.
Yes.
Subject to the provisions contained in clause B, every child up to the age of 14 years shall have the following entitlements for his nutritional needs, namely, in the case of children in the age group of 6 months to 6 years, age appropriate meal free of charge through the local Anganwadi so as to meet the nutritional standards specified in Schedule 2, my lord. And then section 6 says, my lord, The state government shall, through the local Anganwadi, identify and provide meals free of charge to children who suffer from malnutrition so as to meet the nutritional standards specified in Schedule 2.
Yes.
So, my lord, Schedule 2, there is a reference to Schedule 2, my lord, in several provisions, my lord. Now, Lordship kindly comes to page 112, my lord. That is Schedule 2, my lord.
Yes.
My lord, this was the original Schedule 2, which provided, my lord, if you take serial number 1, my lord, children 6 months to 3 years, protein 12 to 15 grams, my lord.
Okay.
And calories will be 500 calories, my lord. Now, my lord, this act has been amended, the schedule has been amended, my lord, this year.
Yes.
That starts from page 115, my lord.
115.
My lord.
Yes.
Now, my lord, at page 118, you lords will see the protein requirement earlier of 12 to 15 grams, my lord, has been enhanced to 15 to 20 grams, my lord. At page 118, fourth column, my lord.
Yes.
Above 1 year, 15 to 20 grams, my lord.
Yes.
Above 3 up to 6 years, again 15 to 20 grams.
Yes.
Now, my lord, in the NIT,
what do
my
you show
lord.
by this?
My lord, in the
15-20 is total fat.
My lord, I'm trying to point out the protein, my lord.
But this column says fat.
Fourth column is protein, my lord.
Okay, 15-20.
15-20.
Right.
My lord, if lordship comes back to the EOI, my lord. Page 50, my lord.
Yes. Yes.
They are still going by the old schedule, my lord, 12 to 15 grams.
When was it amended? Which year?
This was amended this year, my lord, January 23.
Okay.
My lord, our case is, my lord, 12 to 15 grams. This was in the old schedule, my lord. Old second schedule I have shown, my lord, at page 112. There the requirement was 12 to 15 grams.
No, where does it say that?
My lord, page 50, my lord, lords will see. Meghalaya multimix protein in the item in gram, 12 to 15 grams. 12 plus 15.
Yes. 5 months. Okay. Yes. Okay.
So they are going by the old schedule, my lord.
Hmm.
My lord, not only this, my lord. At page 50, my lord, there is a column called vitamin with the name and quantity, my lord.
In
page 50, the table itself, my lord. The second last column, vitamin with the
yes
name and quantity. Lordship will see B12 is 0.25 mcg here.
Yes.
My lord, lordship again comes back to page 118, my lord.
Yes. What does it say?
It says 0.67 now, the requirement, my lord.
This is B12.
B12, my lord.
Okay.
So, my lord, basically what I'm trying to submit, lordship, that they are following second schedule which has been amended, a new schedule is in place and they are following that.
Okay.
And this is a statutory tender, my lord, in compliance with the National Food Safety Act. So they have to scrupulously follow the act and the schedule there too, my lord. My lord, our fourth submission is, my lord, there is no description of the goods, my lord.
Meaning? No description of the goods, meaning?
My lord, what in any particular item, my lord?
Yes.
For example, Meghalaya mix, multigrain mix, my lord. What should be the quantity of wheat? What should be the quantity of rice? What should be the quantity of millet? Nothing has been specified, my lord, in the entire tender.
So you can give me rice, you can give me wheat also, you mean?
My lord, a bidder, my lord, according to his choice.
Okay, yes.
My lord, and I have annexed the tenders of Madhya Pradesh, Jharkhand, Uttar Pradesh, Maharashtra and Tamil Nadu, my lord.
Yes.
My lord, if lordship kindly turns to page 164. This is a similar tender of Madhya Pradesh, my lord. The table at page 164, my lord, it shows Roasted wheat flour will be 57.6%. Roasted soya should be so much.
Yes.
My lord, similarly, my lord.
This has got to some premix. Where you talk multigrain.
My lord, any premix, my lord, they must provide how much will be the wheat, how much will be the barley, how much will be the whatever ingredient, my lord. Similarly, lordship kindly turns to 184, my lord.
So, okay, your basic case is that this tender is faulty. Right. Now, what is the other case?
There is no description about anything, my lord.
Yes.
My fifth submission, my lord.
Yes.
My lord, lordship kindly turns to page 54 of the tender, my lord. My lord, this is a peculiar bid, my lord, where there are no financial bids. We have only heard of two bid system, my lord, technical bid and financial bid. This is a tender where there are no financial bids, my lord. This is unheard of, my lord.
Yes.
At page 54, the lordship will see at clause 3.
Yes.
The EOI must be in the form of the technical bid and each bid must be prepared and uploaded.
Yeah.
So they are only asking for technical bid, my lord. And then the lordship will see at page 56, at the bottom, my lord.
Yes.
Award of contract. The purchaser will award the contract to the bidder whose quotation has been determined to have been qualified in the technical bid. No financial bid, my lord.
No, is there standard rate or?
My lord, what is happening?
Is there standard rate?
My lord,
technical bid, because such I think if some kind of a
my lord,
packet like is there?
My lord,
is
rates
there
are
standard
fixed.
Rate?
Rates are fixed by the government, central government. My lord, page 53. Your lordship will see there's a table in the tender
Right.
itself.
Yes.
My lord, children 6 months, 8 rupees. The first table, my lord.
Oh yes, yes. No, I've seen
12 rupees and 9 rupees 50 paise. But even here, my lord, lordship will see even the calculation is wrong, my lord. The third one, 0.40 paise and 9 rupees 40 paise doesn't make 950, my lord. Even there is a mistake, my lord.
Okay.
My lord, I have annexed 5 more tenders, my lord, of 5 different states where technical bids are coupled with financial bids, my lord.
Where are the let's see.
My lord. Page 229, my lord. This is UP, my lord. The financial bids of only those bidders who qualify in the technical bids shall be opened, which shall be estimated to the technical quality. The rates will be compared with raw material under bid bid so and so. But there is a financial bid, my lord. Similarly, my lord, your lordship will find at 163 also.
No, but is there a fixed rate? No.
My lord, central government has fixed a ceiling rate, my lord. What government of Meghalaya is doing, tender at the ceiling rate, my lord.
Okay, well and
You go at the maximum, my lord.
okay. And then what else?
My lord, a similar clause is there in the financial bids, my lord, of Madhya Pradesh at page 163, my lord. My lord, all of the tenders, there are financial bids, my lord.
Okay.
And that is what we understand, my lord. The tendering process involved 2 stages, my lord, technical evaluation and financial evaluation.
Yes. Yes.
My lord, my next point, my lord.
So, you agree with the criteria that has been given in the. Now, your submission is that with this criteria is impossible for anyone to bid.
My lord,
Correct?
firstly, it is against the statute.
Are you just pointing a discrepancy, or are you trying to say that these criteria you can't meet?
This is
or
against
this
the
should be changed, or they
my
be
lord,
tailor-made
my
for
lord,
someone.
I am on both counts, my lord. Some criteria need to be changed, my lord. My lord, there's one more criteria which I want to point before your lordship, my lord. Your lordship again comes back to the tender, my lord, at page 58.
Yes.
My lord, how they'll do the evaluation of technical bids only, my lord? They have earmarked certain points. Manufacturing license 10 points.
Yes.
FSSI 10 points, BIS mandatory 10 points, average turnover so and so, so and so, so and so, so and so, my lord. Total 100 points. At the bottom they say, my lord, minimum points required for qualification in the EOI is 85 points.
Okay.
My lord, unless somebody has 85 points, my lord, he'll be disqualified. Then at serial number 8, your lordship will see Factory in northeastern state of the bidder, 10 points.
Yes.
Supply of micronutrient energy dense food under so and so in northeastern states for last 3 financial years, again 19, 20, 21, 22, my lord, 5 points. Now, my lord, if somebody is not from northeast, my lord, he does not get this 15 marks, my lord. He is left only with 85 marks, my lord. His full marks is 85. And the cutoff itself is 85, my lord.
Yes, 85.
Cutoff itself is 85, my lord. In my humble submission, this is...
So if we meet 85, we'll qualify.
My lord, I have anybody from outside northeast has to score 100% on the 85 marks, my lord.
Right.
But somebody from northeast, my lord, he gets this 15 marks extra, my lord. Not only that, my lord.
That's logistics, you know, the thing
Not
is that
only
if your factory is here in the northeast, whatever, then it makes sense to have, you know, a local kind of supply who meets the criteria or requirements.
My lord, I'm submitting.
I don't think this.
My lord, I'm submitting this as a last point, my lord, in a descending order, my lord.
That is not really, you know, material.
My lord, why coupled with clause 11, my lord? Lords will see clause 11 at page 50.
Yes.
It says, my lord, the bidder who qualifies in EOE.
Yes.
And having factory in Meghalaya will be given preference. My lord, supposing that I score 85, my lord, I fulfill 100% of the remaining, my lord. And somebody having factory in Meghalaya will get preference, my lord.
Why not? Because if all things are equal, then that preference comes only then.
In the first place, there is a preference over preference, my lord. First, you get 15 marks extra, my lord, for qualifying. Then you get preference.
I think because they will have the latitude, you know, to make, you know, the condition, the tender, according to what they feel would, you know, serve the scheme the best. So at regard to location of factories and, you know, these other points, I don't think you'll have a case. But with regard to maybe non-compliance with the directives or as per the act, then maybe there might be something. But I mean, are you saying that you can't meet the criteria on these 2 points? That you don't have factory and the 15 marks is like a handicap?
My lord, even if I score 85, my lord, and somebody from northeast scores 85, my lord. Now again, because he is 85 because of 15 extra marks, my lord.
How do you score 85? Okay, fine. Yes, that's 10, 15. Okay, factory northeastern state bidder. Okay, fine. Yes.
So from Meghalaya, somebody or from northeast, from Guwahati, my lord, he scores 85 because of 15 extra marks he is getting, my lord. And plus,
where are you located?
We have a plant in Jharkhand, my lord, in Rajasthan.
Okay.
So, my lord, this is one of the 6 points, my lord, which I'm trying to impress upon lordship. My lord, this tender is a copy paste from Assam, my lord. This particular NIT.
So in Assam has the same defects.
We laid a challenge before the Guwahati High Court also, my lord, and the government of Assam has withdrawn the tender day before yesterday, my lord. I'll place those orders, my lord. My lord,
no, it doesn't comply with the statutory provisions, whatever the schedule, then that they have to re-examine that. Well, it concerns food to, you know, the very depressed section of society.
They are required to comply with the statute, my lord. This is against the statute, my lord.
Yes. Yes.
Yes, my lord. No, 2 aspects, my lord. One is, my friend has first point is that the financial year for 22-23 should be taken into account. The fact is, my lord, that petitioner has in the entire writ petition has not averred a single line that it is meeting the requirement. So possibly for 22-23 audited account will come by 31st October. Last date of audited account is 31st October, my lord. Kindly see the provision of EOI, my lord, in this regard. Because the petitioner is not eligible, therefore he is nitpicking all these issues, my lord. I will show how and how we can resolve this issue, my lord. Kindly see EOI, which is at page 49, it starts, my lord, and the concerned provision which my friend has challenged is at bottom, page 49, clause 6, my lord. Documents relating to past experience of supply of micronutrients fortified dense food to Social Welfare Department of rupees 10 crore each in last 3 years, 2009, 19, 20, 2021 and 21, 2020. Order of copy and work completion certificate to be enclosed, my lord.
Yes.
And at 20, my lord, at point 20, my lord, you lordship will find at point 20, manufacturer should submit the annual financial statement for last 3 years. Page 51 at point 20, my lord. The manufacturer should submit the annual financial statement for last 3 years duly audited by chartered accountant. So the audit will be over for 23 by October only, my lord. So there is nothing wrong with this clause. of finance. Now, second point which my friend has said that there is a schedule which has been notified in January, which changes the protein and other requirements. My lord, when we float the tender, possibly we may not be having this. But in pre-bid meeting, my lord, the parties or those who are tenderers, they raise all these issues, and we do modify the requirements having regard to. So to say that it is a complete finality, so with regard to protein, etc. means, because this is this tender, my lord, requires the urgency is there because we have to supply the.
No, we understand urgency.
Fortified nutrition, and there will be some. And January, this notification has been, and thanks to my friend, he has pointed out, my lord, whatever is missing. 8th pre-bid meeting is there. In pre-bid meeting, all these issues we can modify, my lord. First thing which my friend should satisfy whether he is eligible to participate in the bid or not. If he is not eligible, then, my lord, other points can be taken care by the department, my lord. If there are issues which are not in conformity, we can't shy away from that. So if he is not eligible, my lord,
what about his valid eyesight certificate? How is your tender doesn't have any financial? Why is not two parts?
No, my lord, they are two, because first you have to meet the technical parameters. Once you meet the technical parameters, my lord, ultimately it has to be evaluated on the basis of financial.
That means after people meet a technical bit, you'll have a pre-bid meeting and
yes,
start having auction.
My statement may be recorded.
Auction then at that pre-bid meeting with regard to the
final price is fixed, my lord. The highest price is
fine. MRP might be MRP is fixed.
Now if the party and that MRP has to be followed, I can't exceed that, my lord. Now bidding has to be within this range, my lord. For example, 3 technical bids are cleared in the tender, my lord. Out of 3, whom should I give? I can't prefer 1 or 2 or 3, my lord. What my friend says that you should have factory or the unit in Meghalaya or near or in Assam.
See, one thing, Mr. You can't have a kind of cartelization. If after your technical bids you've passed and you go and have a period meeting where suppose Mr. A, B, firm A, B, C sitting, doesn't mean that before they enter, regard to, suppose they all quote at the maximum, who will you choose?
Then, my lord, we will see for example, what has happened last.
You already passed technical bid. You're stopped from again re-examining the technical aspects. You're looking at the financial aspect.
What has happened that there is a marking system in grading there is a marking system which has been pointed out.
Your own submission just now. You said that 3 people have qualified technical bid. They will come private meeting and we will they will have an option.
Now, see, if I admit, my lord, I have no hesitation. If there is an anomaly in this part, assuming for the sake of argument.
There is an anomaly on that part. I will interfere.
I will try to persuade. No, I will try to persuade your lordship. The point which I was trying to make, my lord. For example, what has happened, your lordship has seen that these are the foods which we will get from central government. It has to be fortified. Now, if there are units having in Delhi or Noida, they will take the food from here. The FCI go down is in Guwahati. They will take it.
We're not into the logistics side now.
So therefore, now the coming back to the financial aspect of the matter. How do we allot the tender? My lord, I assure, my lord, if there are issues, we will resolve it. We will do it in transparent manner. I will file the detailed reply on this aspect of the matter.
When is the tender closing?
Tender is on 8th, my lord. Pre-bid meeting is 8th. The date is.
You come back with instructions
on this aspect
and because see, court's not happy with there's no financial bid.
No, your lordship, kindly see.
What does that open? It opens the entire field for for going and what do you call it, for bidding. It's like bidding for some.
No, my lord, what I am trying to say, if your lordship will see the financial bid aspect also, kindly see the terms, because what my friend was first, he is not eligible. Admittedly, he is not eligible, my lord. Once he is not eligible, my lord, kindly see the deadline which we have.
Notwithstanding that, with arbitration, notwithstanding that.
Yes, my lord. So now,
notwithstanding the award of contract as per UI, I think, as he submitted, it will be on the basis of technical bid.
No, it will not be on. It will kindly.
That's very disturbing.
It will not be on technical bid, my lord. It can't be on technical bid.
We know how to go behind closed doors.
Your lordship, kindly see the clause. Kindly see the clause. 56, my friend has 56. Let 56. I did not interrupt my friend.
56. Yes.
Award of the contract. The purchaser will award the contract to the bidder whose quotation has been determined to have been qualified. This is. I will give this. I'll just satisfy, my lord. What is being read into this is that once you qualify technical bid, you will get the award. No.
No, absolutely not.
So it says that only the clause is, my lord, that if you qualified in technical bid only, then your bid will be considered. It's not if you are not qualifying in technical bid.
Exactly, that it comes up for auction and for.
It's so now the question, my lord.
They're not even asked for financial bid, my lord. Where is the question?
Your lordship will see, the purchaser will award the contract to the bidder whose quotations have been determined to have been qualified in technical bid.
Exactly.
So what the point, which is
you don't need to submit, it speaks by itself.
No problem, my lord. On this issue now. On this issue, I will clarify, my lord, what process they will follow and what is the process, because these matters, your lordship will see. Just see the page 52, my lord, page 52.
Yes.
And this is start date is 8th August. And then your lordship will see their timeline given, my lord, 88/9/2023. Your lordship have it on Monday. Today is Friday.
Monday.
Monday.
So one
Tuesday.
thing
Monday.
We'll file. Disturbing is you cannot craft such a tender that will give fair play in the joints.
That I bow down.
Doesn't mean
that we cannot do.
Doesn't mean that becomes
we cannot do. That I fully bow down, my lord. Your lordship had it on Monday.
Mozika, then it comes to the petitioner. Issue notice. MS Lalu with the Advocate General, assisting Advocate General will accept notice on behalf of all the respondents before a notice call for a stop. Should we observe anything? Only
nothing, my lord. Monday we are coming. Only thing is that if my petitioner should have stated to the petitioner whether
Appraiser be allowed to obtain instructions. List the same on Monday. In the motion call.
Monday. If
you can't have this kind of thing.
No, I understand. I'll put the chart, my lord.
You craft a tender where and people sit and then you come.
We'll clarify, my lord.
At that time, before somebody, those seal covers will go. I mean, seal goes will go to bid.
We will clarify this aspect.
Outside the tender.
Absolutely. No, we will not. But only one thing, my lord. Only one thing. Only one thing. My friend has to satisfy your lordship whether he is eligible or not.
Of course, that will come. When it comes to notice of the court, that tender is defective, notwithstanding locus.
Only one aspect my lord, the tender contract period is 5 years, my lord. Extendable by another 5 years, my lord.
So what is the problem? That period, we can't have tender every year so that litigation can go.
Every state can have. Meghalaya can.
Yes.
Main list, item number 2.
What is this?
Your Lordship, the respondents here yet to file the affidavit.
But we are filing the course of the day.
Yes, Dr. Mozika, what's the matter about that digging of the well?
Blacklisting, for digging of the bore well.
Yes, Dr. Mozika and DSI submitted the actually find the course of the day. According list, you want to file a rejoinder?
Your Lordship.
It's up to 2 weeks for rejoinder, if any. Yes.
Item number 3.
May it please your Lordship.
Yes,
Lordship, this matter was taken up last occasion 1st of August.
Lordship was granted time for filing reply. We seek some more time. We'll file the reply. The documents are voluminous. And
this is that outstanding.
I do not have an objection to my learned friend's accommodation. I have only one indulgence to make. Subsequent to the filing of this writ petition in the order, we have also brought on record an IA. We have communicated the order to the respondent authorities. What is happening, your Lordship, if you recall, we are going and asking for making an application to please grant me new electricity connections and we will pay. But there has been no response. Although the order provides that no coercive steps, there is a one part of it. One is the demand made prior to the CIRP period. That is to be decided on affidavits, and the other part vis-a-vis is that we have made a request. You please process my pending application. My right is getting affected.
Why not processing it?
I will just satisfy my lord. The writ petition. In the writ petition, what they are praying is that the dues which are payable are covered under the scheme under IBC code, my lord. That issue is being examined. Your Lordship has only said that we should not take any steps to disconnect them.
Yes.
First, they have to satisfy but whether they are liable to make the payment. And now they are asking for positive mandamus. Positive mandamus that we should give them electricity connection irrespective of fact they have cleared the past dues or not.
I'll just clarify. I understand what my learned senior is saying that. my writ, the reason we have come up before is that when I went and made an application, which is part of it, that you please grant me electric connection, I was refused, stating there are prior dues. I write to them, you please indicate first what are the dues pertaining to. Because according to us, if the dues pertaining to a particular period, we say not payable. If it is post that, we are ready to pay. That is number one, for which your lordships heard and said no coercive steps. But subsequently we came and said, we are giving an undertaking. Look, you please first process my new applications. I am not able to run. Your lordship's order was no coercive steps. Their inaction is also affecting my right to business.
No,
I am not running away.
Coercive step means do disconnection.
No, your lordship, no, I understand. But your lordship, I understand. But the spirit of the order, your lordship, I have put in. It's not that anywhere. I am only seeing a simplicity submissions. I have applied for fresh electric connections. I am ready to pay, subject to whatever is the outcome of this. That should be processed. There is no difficulty with my learned friend.
If my friend is saying that whatever
new electric connection in accordance with law,
amount is due and payable.
No. Your lordship,
and subject to undertaking an outcome. If he is ready to pay,
no.
process.
This is being. I said subject to outcome of this writ petition. You should not prevent me from applying fresh connections. Kindly advise my learned senior to instruct you. Please process the fresh connections. I am not taking any refuge of the order. I am saying.
Where's your IA? Where's your
My IA is not on record, but it's been filed, your lordship. That's the IA.
This case number for fresh connections?
Yes. Lordship, kindly comes to internal page.
This IA is not listed.
It's not listed, it's been filed, but I was told it's not listed.
It's not listed, yes.
Milord, kindly give me 2 weeks time, we'll file reply. Lordship,
May I indicate? Kindly comes to page 17 of my what? There is no animosity. What
your petition
of my IA?
It's not listed. We can't take it up.
Lordship,
you should have mentioned in the morning. Not listed, huh?
It's not in context. It's not there.
It's not showing in the causes, but I'm sure that it's being filed and it's there. Lordship's file is with the lordship.
Number 191, not 238. Not 238. There's only one. Don't go in this case. Other mistake numbers what?
It's not listed, Milord, so that.
You have a copy with you?
Yeah, I have the copy. Advance copy has been supplied.
Fresh one's 169. Oh, fresh one's 191. Okay.
So kindly comes after we got the order, your lordship. We communicated the order. Kindly comes to internal page 17.
17.
Yes. Lordship, this is the response from one of the officers of the respondents. Your Lordship, I am placing that. With reference to the subject cited above, please find on letter dated such and such from lines. This in relation to the application of power connection of subsidiary companies at the office such as on account of accumulated dues, no claim not obtained from the authority. However, in light of the recent High Court order, the undersigned would like to request you to kindly take up the matter with the appropriate authority from your end. And the application from above will be withheld and the same shall be processed after obtaining it. Lordship, I am only submitting whatever is the challenge in this court in the writ petition, that leaving apart. I am entitled to carry on my trade and business, to have fresh connections. I am only asking them to process submit my fresh electric connection. Let them not hold on.
They do not make the payment. They take this.
One thing, Mr. Rafizar, you take. Have you been served a copy of the Mrs. application?
Yes, this application has been served. I have seen in the morning.
You have a look at it and then you come with instructions. We'll have it next week.
Your Lordship may have it in collectively. What I say, what my friend.
Collectively, we'll have it. We'll have the whole matter. But even then,
I'll file the reply.
They only what they are trying to say. Because I think I understand.
Yes.
Is that with regard also Indian dues that we divorce that from the entire.
That is the only issue which
present here.
Whether a consumer who has not paid the dues for past, whether he is entitled to fresh connection. That is the because this is linked with the main matter, my lord. First matter is because every new consumer, my lord.
Okay,
every consumer will.
This case number 191 to 23. Stop. This is an application. This application has been listed, has been placed today before the court, though has not appeared formally in the list. Stop. However, the same taken for consideration by the instant application. The petitioners playing for appropriate orders for the respondents to consider the application dated, the application for fresh connections, yes, to their establishments Stop. Mr. A. Kumar, Mr. A. Kumar, Leonard AG, appearing for the respondent corporation, raising without to obtain instructions on the same. Stop. And main case?
Main case, Your Lordship, kindly give me 2 weeks' time. To both the matters, we will hear, because ultimately
that is the reason I said I don't have a difficulty in taking time, but 2 weeks, Your Lordship, understand I am not able to carry on. Let them, what is falling from my Lordship is that let them process my new application.
So let them examine it. He can't give undertaking.
At least let them answer. They are not even answering.
They'll answer in this case. Don't worry. I think so this Mr. E. Kumar, Mr. Accountant General submits an email out to obtain instructions. Stop. This court further directs that the positive instructions should be obtained before the next date, as to the fate of the application for fresh connections, notwithstanding the outstanding dues that are present, and is the subject matter in the main petition. Stop this together with so and so. This together with the main petition after 2 weeks on so and so date. In the main application, Mr. E. Kumar appearing for the respondents, please will allow further 2 weeks time to file affidavits. Prayers allowed this for 2 weeks. Yes, there's some put together.
Great.
Your name?
My name is VVV Shastri.
Record.
Item number 4.
Madam, there has been a problem in finding out the addresses because there was criminal cases between both the parties and there were quarrels before. So my client is unable to go and find out who is the successor in their house. So I may be allowed to publish the notice in the newspaper.
It'll take too much time. They can inform you.
I'm afraid to go there because they may
who's
attack
the
me.
succession interest
Cannot
of
go
the
to their house and find out.
I'll have to find out.
2 and 5 have died.
Yes, sir.
2 have died and 1 has shifted his residence. He is in Joy only, but his exact residence has not been found out. That's why I may be allowed to publish in a local newspaper.
They are not interested, my lord. Even in the
They have not appealed against the original order also, these 3.
Mr. Bora Prince was allowed further 2 weeks time to obtain the correct address of the respondent number 5, and also to obtain also to ascertain as who the successor in interest to respondent number 2. This after 2 weeks. Yes.
Item number.
Next matter.
Item number 5.
Yeah. Your Lordship's indulgence before your Lordship takes up item 5. In item 3, the interim order which is continue will continue to the next date.
Okay. Yes, of course. Yes.
Item number 5.
Yes.
May I please, Your Lordship, the notice has already been delivered.
Or received?
Yes.
How do you know? You have received
Yes,
information has been received on a sole respondent.
Yes.
Who's appearing? It's a contempt matter. Personnel and AR department.
Lordship, as per my knowledge,
have you been instructed?
No, Lordship, I haven't been instructed, but I've received information that Madam R. Lingdo has retired. But I'll seek instructions with regards to the representation, Lordship.
Yes, you are M. Hajong.
Yes, Your Lordship.
Ms. M. Hajong submits that, office note indicates that notice has service report not yet complete on the sole respondent. Stop. However, Ms. M. Hajong submits that yes, obtained status of post department.
Yes, Your Lordship.
Where is that? Let us see. Has obtained status that the service has since been completed. Stop. She is permitted to file affidavit indicating service on the next date. Yes, you file with your affidavit, yes. List after 1 week. I won't record anything in order, you can find out in the meanwhile. My lord? I won't record anything in order, you can find out in the meanwhile.
Lordship.
Item number 6.
I do oblige.
Contempt matter, yes.
My lord, I am entering appearance on behalf of the respondent number 1 and 2, my lord, as a president and the secretary of the managing committee, my lord.
How many respondents are there?
There are two respondents.
Only 2 respondents?
Yes, my lord.
Mr. P. Ubin, presents appearance today on behalf of respondents number 1 and 2 and praise for?
My lord, I would like to file a short cause, my lord.
How much time?
2 weeks time, my lord.
Praise for 2 weeks time to file show cause to the application and stuff. Praise allowed it for 2 weeks.
All right.
7.
Yes, NIT matter.
NIT matter?
Yes.
Or a national?
Training teachers.
Where's the affidavit? Ready?
But in the other matters you file an affidavit. I'll just file in this matter also. This is a affidavit. Some more time.
Mr. Samba, you allow them some more time? No. Dr. Mosika praise for allowed further 2 weeks time to file affidavit. Interim order passed earlier shall continue till next year.
8.
Please, Your Lordship. Lordship, I'm praying for another 3 weeks' time to obtain fresh instructions. The instructions which we received, my lord, are slightly
woefully inadequate.
Inadequate. They have wrongly constituted the issue at hand. This is regarding This is regarding the, my lord. There was a rule by which the gratuity has to be paid in the district council.
Yes.
In pursuance to the rule, they floated a notification wherein a formula was given in the form of a mathematical formula. But that formula, my lord, doesn't appear to be in consonance with the rules. But their pairwise comments are slightly on a different aspect. So we have clarified, my lord. I'm requesting
2 weeks time. Ms. S. Deb submits that the instructions as received are inadequate. Such he prays and allowed for 2 weeks time to obtain instructions and file affidavit. Yes. Praise allowed this after 2 weeks. Yes.
Much obliged.
9.
This matter is in an advanced stage of conciliation. Another 10 days time, hopefully we will be able to resolve it.
No idea.
No results yet. The petitioner personally went, Your Honor, but then there was a talk that they'll withdraw the letter. But till date, no letter has been withdrawn, Your Honor.
Next 10 days time, just yesterday I spoke to them. It has gone for auditing. The auditor will, the moment he does that, the matter will be resolved.
Dr. Mosika submits that the matter will be resolved positively within 10 days. Settles this matter accordingly and so and so. You remark Mr. Wanswet's presence will be out of petitioner. Wanswet, correct?
Wanswet.
10.
Lordship,
You're not filed affidavit till now.
Oh, yeah, Lordship.
What is wrong?
I will file it in the course of the day.
Are you very prompt usually?
Yes, Your Lordship.
Why?
In the course of the day, Your Lordship.
Ms. S. submits that the applicant filed the course of the day on list after 2 weeks for rejoinder of any. Yes.
Obliged, Your Lordship.
This is also for affidavit note.
Your Lordship will file this also in the course of the day if you just received instructions.
Same order.
12.
Okay, my lord, affidavit has been filed today. We have served the copy, Lordship. I'm praying it can be taken up for hearing.
Ready? Just hear it.
Whether the affidavit is on board?
Yes, it's here. What's the matter about you? Ready, Mr. Sheikh?
Pensionary benefits, Lordship. I'm praying for
Pensionary
some
salary,
time.
Lordship.
Yes.
The petitioner has been retired on 31st/1/2020, Lordship. Everything has been sanctioned by the department.
Only affidavit they always file. What is the common refrain all the affidavits regarding pension by the HDC?
This is a
shortage of funds. That's the only thing. They don't need to file affidavit. Yes.
We are not disputing anything, my lord. I'm praying let it be taken up for hearing. Maybe we'll try to.
So because
I can hear it now. What is there?
I don't have full instructions for
the only thing is acute shortage of funds.
Lordship, as per the affidavit, yes. Let it come up online because most of these matters are usually resolved. That's why I'm saying.
Because now we'll pass an order for 3 months, then they'll come to contempt. Then slowly how the matter goes on. You see,
I'm
comply with it because you can't comply.
File the affidavit, my lord, in very short notice. Let it be taken up for hearing. Already there is an order, my lord, that the pendency should not be a bar. Maybe,
but they will not release. In
Yeah,
next
it's been filed by the respondents. As he was taken on board, stop this matter for hearing up to 1 week.
Hello. Obliged.
13.
Your Lordship, under item number 7, that interim will continue.
Item number?
Item number 7.
7 is what?
That NIT.
Who's appealing this matter? We'll see. You don't mention the middle list. Even the earlier council mentioned the middle list. No. Yes.
13.
Interim will continue. That's only the yes.
Your Lordship, here the respondents are yet to file the affidavit.
What about number 9?
Number 9, service has been effected, Your Lordship. I may be allowed to file my
You
service.
file affidavit.
Your Lordship, if I may be allowed to file my service affidavit.
Who's appealing for number 9?
NBCC, Your Lordship.
NBC, they have a standing council, correct?
Your Lordship.
Who's file affidavit?
This is an identical matter that is Kamen Mirchiang WPC number 496 of 2021. So my instruction that we have filed an affidavit in that matter, my lord.
Is it correct? Is that correct?
Your Lordship.
So you don't have to fill affidavit here?
No, that is my instruction.
WPC number?
496 of 2021.
496?
Yes, of 2021.
Is with regard to same land?
Yes, Your Lordship.
So why the two petitions?
Your Lordship, here the petitioners are different. This is with regard to East Khasi Hills. Kamen Mirchiang is with regard to West Khasi Hills and Jaintia Hills.
Issues are identical.
Are you sure?
My lord. Indo-Bangla.
Mr. Dr. M. Mozikan, we have respondents number 1 and 2 submits that in a similar matter, namely WPC number
496 of 2021.
496/2021.
Kamen Mirchiang versus
Kamen Mirchiang versus Union of India. Affidavits have been filed, which affidavits have been filed by the Union, which will suffice to address the issues raised in the present petition. So as such, he submits that. Oh no, that's fine.
the only difficulty was that the other matter has gone to court number 3. My lord. The bench is different.
Then we have a problem. Should we send this matter there also?
Can we decide to identical issues?
I'll have to seek instruction.
Do you have any objections to the matter we taken up the earlier matter? Because earlier matter will hold proceedings.
Your Lordship.
Earlier matter take proceedings. I mean, whatever
Your
is if these are on similar lines.
Your Lordship.
Can we tag to along with that?
List this matter together with the settled petition before the appropriate bench, which is seized with the matter. SEIZED, not CESET. Yes. What about the other respondents? No affidavit. No.
Lordship, actually, if I can make a submission, since they will be relying on that affidavit, if you can be supplied a copy.
That's between you senior counsels only. What about 3 to 7? Mr. H. Koraram, to have 3 to 7. Please be allowed further time. Stop. This is a matter together with which is allowed. Yes.
Much.
14.
Please, Lordship.
Counter is out.
Lordship, I pray for some more time. I'm yet to receive instructions on this matter, Lordship.
A fresh matter.
Yes, Lordship.
Please
This is the second
for
time.
the 3 weeks time to file affidavit list thereafter. Also.
I do oblige.
Lordship, this matter is very limited prayer.
the director to just to give a approval to the interview board or to consider it.
Yes, I have come up with the instruction, Your Lordship. Your Lordship, as per the instruction I have received, they have submitted a resolution directly to the higher authority. That is the respondent number 2, Director of the School, Education and Literacy. Instead of submitting to the district education officer, yes, it has to go through proper channel. First, they should have submitted to the DEO, District Education Officer. Then, accordingly, the DEO would have forward to the higher authority for its proposal.
It may be disposed of in that way.
Yes, Mr. Emakudi submits that the corrections by way of interpretations only for approval of the interview board. To be constituted for the purposes of selection of assistant teachers. Stop on 23/8/2023. This court directed the London GA, Ms. E.M. Sangma, to obtain instructions on the matter. Stop. Next part today, Ms. E.M. Sangma, London GA submits that the only hindrance is that the said letter seeking approval was addressed to the wrong authority. So, which should is also named as one number 2 when the same should have been given, should have been submitted before the.
It has to be submitted to the respondent number 3 also.
For the respondent number 3. Stop. Next para interview the matter. Ms. M. She prays that we are allowed to withdraw this matter.
I may be allowed to submit that much.
Yes. The matter allowed to submit before the competent authority for process. Yes, as per law.
Yes.
Matter only stands close on withdrawal in terms of in terms of the no, this is matter stands close to withdrawal with what are you saying with allowing the petitioner to submit the application before the before spot number 3?
Yes.
Hearing 17.
Lordship, here I am impugning the order dated 20 February 2020, Annexure 9, page 41, and the operative portion is at page 49.
Page 49?
49, operative portion.
Page
49, operative portion. I may be allowed to read. Therefore, as the marriage between the petitioner and her deceased husband, late Carlos Lamin Gayang, has been solemnized as per Catholic rites, hence I find and hold that based on the marriage certificate at Exhibit 1, the petitioner is the legally wedded wife of the deceased, late Carlos Lamin Gayang. Therefore, in view of my above observation and findings, I am satisfied to allow the instant case. The case is allowed and the petitioner is hereby declared as the legal wife of the deceased, Carlos Lamin Gayang. Lordship, the genesis of the case is that my husband was working in the Directorate of Information and Public Relations. So after his death, the department has directed both me and the respondent to obtain a court order declaring who is the legal wife of the Carlos Lamin Gayang. However, the respondent, Lordship, neither filed a title suit nor a intest succession petition, but filed a miscase before the London District Council Court. So, Lordship, kindly come to page 53, Annexure 11. That is the miscase filed by the respondent. Lordship, I will be allowed to read the operative portion of the petition, that is page 55, para 3. That the petitioner states that the marriage between the petitioner and her deceased husband, Carlos Lamin Gayang, was later solemnized, rectified on 13/2/2000 at St. Paul Church, Lamai, Upper Shillong, by one Rev. Bector Lingdo, and as such the marriage between the petitioner and her deceased husband could not be registered before the competent concerned marriage officer to prove their marital status.
Yes.
that the deceased husband of the petitioner during his lifetime was working and serving as the ex-driver in the office of the Government of Meghalaya Directorate of Information and Public Relations, Shillong. That the petitioner states that the deceased husband of the petitioner, Carlos Lamin Kayang, due to his prolonged illness, expired on 5th May 2019 at Civil Hospital, Shillong. That the deceased husband of the petitioner, Carlos Lamin Gayang, has given the nominee in his office in the name of the petitioner and his 4 children. That the petitioner begs to state that besides her deceased husband, Carlos Lamin Gayang, have no other legal wife, and she have no knowledge if there is so before or after her marriage to him. So, Lordship, here she is stating that she is stating that she doesn't know anything, but where the department by letter dated 14 January 2020 had directed me and the respondent.
Which page is that? Where it
Page
is from?
36, Lordship. Page 36.
Page?
Page 36. Page 36. Page 36.
Yes.
I am reading the operative portion. From the relevant papers notes on the record, it has been noted that there involves an issue of claim and counterclaims between the parties in respect of the pension and pensionary benefits of one Carlos Lamin Gayang, ex-driver, Directorate of Information and Public Relations, Government of Meghalaya. It is noted further that there are 4 claimants in this instant case. Therefore, the department may not be in a position to decide on the question as to who is the first, second legal wife or the rightful heir of the deceased government employee for enabling to invoke the applicable provisions of the Meghalaya Civil Service pension rules. Under the given circumstances, in order to resolve the issue in hand, the interested parties may in the first place be required for obtaining an appropriate order declaration as legal wife heir from the competent civil court of having jurisdiction. Civil court having jurisdiction. So, however, Lordship, she did not disclose this fact, and she has filed a miscase. Accordingly, the respondent has obtained.
No, why my miscase? That is what. Now the thing is that it was given from whoever to whoever the letter. But says that they go to competent court. So
Yes,
she went
yes.
and filed a case.
No, she did not make me as a party. She did not arrange me as a
She
party.
doesn't know who you are.
It is categorically written, Lordship. There is a
Where's
claim
the
and
name? Where's your
counterclaim.
name given here? That from it's been noted there are many claims. She's gone.
Lordship, kindly come to page 35. Page
35?
Yes.
She knows about existence.
Yes, she knows. Lordship, it is written to Sarita Kharkungar, Dominica Dakhar, Srimati Hilda Dakhar, respondent, Srimati Jasmine Kharkungar.
Yes.
Pension and pensionary benefits of Carlos Lamin Gaya. With reference to the above, I am to enclose here with a copy letter number so-and-so received from Joint Secretary, Government of Meghalaya, Information and Public Relations Department pertaining to pension and pensionary benefits of Carlos Lamin Gaya, ex-driver, which is self-explanatory for your information and necessary action. It's clearly she knows, Lordship, but she did not arrange me as a necessary party, Lordship.
So what can you do?
So, since I am the legal wife, Lordship.
Do you have what documents you have to show that you're legally wedded wife? You have marriage certificate?
No, Your Lordship.
Your wife number?
I am the first wife.
The wife
I
number
married
1.
in the year 1990.
And
I
this
started
Jasmine
college.
Kharkungar?
Jasmine Kharkungar is my daughter.
Is your daughter. Then this Dominica Dakhar?
I believe a daughter of Hilda Dakhar.
Hilda Dakhar is?
Respondent.
Is a respondent. So that means you are Sarita Kharkungar.
Yes.
That means you and your daughter?
Yes.
And the second wife and her daughter.
Yes.
Correct. Okay.
So, Lordship,
And the name of the second wife is entered in the
service record. That also when
is your daughter major now?
Yes.
She's major.
Yes. And that also they have entered their name in the service record only just before 1 month when he expired. Only before 1 month of his death.
Doesn't matter. The fact remains that as a nominee, the name is there.
Yes. So
what is your claim? You never registered a marriage. You got married which year according to you?
1992.
1992. And when did he marry
Prohibition, Lordship. I have
Mr.
studied
Yuban's
prohibition.
client?
Sorry, Lordship.
When did you left her Or you left him, or
No,
she
no, no.
left you, or
He
what?
deserted me.
Deserted
He
you.
deserted me, and thereafter I filed and one maintenance application also, and I was granted interim maintenance.
Okay.
And during the pendency of the maintenance petition, my husband expired.
Yes.
So, Lordship, I may be allowed to place one decision of the Honorable Supreme Court, Lordship.
So your only prayer is that this order says you also should be heard. But then on the fact and circumstances of the case, if the second wife has a valid marriage certificate and you don't have, so even you're not entitled, if your daughter's only major, then she won't get anything also.
No, Lordship, here, Lordship, they do not have the marriage certificate. They have solemnized the marriage as per the Christian Act, Lordship.
Doesn't matter once that is proven on by way of evidence.
So, Lordship, I may be allowed to place some decision.
You place what decision to place?
All right, Lordship.
I can't stop you from placing the decision, that you have to argue a matter.
The decision is quite voluminous, so I just printed the relevant portion, Lordship. The
only 2 pages.
next page, Lordship, that is paragraph 20, Lordship. Paragraph 21, Lordship. This court, in the case of SP so-and-so, has held that non-disclosure of the relevant and material documents with a view to obtain an undue advantage would amount to fraud. It has been held that the judgment or decree obtained by fraud is to be treated as a nullity. We find that Respondent number 9 has not only suppressed a material fact but has also tried to mislead the High Court. On this ground, also the present appeal deserves to be allowed. So, Lordship, here the respondent did not disclose that I am also an interested party in the case, and she has filed the miscase. Thereafter, Lordship, I rely on one recent decision of the Honorable Supreme Court.
How do you class this petition filed by the respondent? What kind of petition is it?
Miscase, Lordship, they have filed.
Miscase, yes.
That is what I have stated. They have neither filed a title suit nor a intest succession, Lordship. They filed a miscase.
And what's that 14th February order say?
It is saying 20 February, Lordship. That is saying that the operative portion is at page 49, the impugned order, Lordship.
Now what's happened to the, is still held up the entire time, or she's enjoying it?
They have received some benefits, Lordship.
Where is that? Yes, this is 14 January.
Yes.
You didn't go to the competent civil court?
Sorry?
You didn't go to the court to establish your marriage?
No, Your Lordship. Lordship, I have stated due to some financial difficulties, and also at that time pandemic was there, Lordship, so I could not approach. I have stated, Lordship.
That doesn't make your case better. What do you have with judgment? What does it say?
Lordship, it is saying that cohabitation amounts to marriage, Lordship. Cohabitation. It's a recent decision because I studied cohabitation, Lordship. I have cohabited with my husband since 1992, Lordship.
But then this child was born with this respondent in 19. Where is that petition?
Operative portion, Lordship, is at page 8, para 10, Lordship.
There is no, what do you call it? What does the judgment say?
Lordship is saying that prohibition.
Okay, very good. But then everything is based on the particular, facts and such of a particular case. It's not that one formula. In cases like this, the facts have to be examined. What kind of cohabitation? How many issues they had?
Yes.
What the length of cohabitation? Were the other claimants?
Lordship,
and in this case, I think at the time of demise also, the person was staying with that lady.
Lordship.
Correct.
Lordship.
So that's why inference is drawn by the court that yes, this cohabitation that means entitles her to the estate of the deceased person. That's the only thing.
Lordship.
Now, in your case, the thing is that you say that you had all filed your claims, correct, before the concerned department. Now, since there are 4 claimants, so they cannot decide as to who to give it to. So they said, go to competent court. Now, you didn't go.
No.
You slept. You said, then forget it. Once you sleep over your rights, then you're not bothered anymore about your what you feel you're entitled to. You didn't go because pandemic kept you back fine.
No, it's not.
But the respondent went.
Lordship, it's not like that. Even
so you're waiting for the respondent to go and file, make your party so you can contest it?
No.
What?
It's not like that, Lordship.
It's
Lordship,
like
even
what?
I filed representation before the department also, stating about my financial condition and some personal difficulties. I could not. Then and only they have informed me about this impunity, Lordship.
See, the thing is that, Mr. Deb, the thing is that whatever department said that fine, go to competent court. They brought a court order.
But they have not added me as a necessary party. Well,
it doesn't matter.
I was
they are asserting their own rights only.
I was not heard also, Lordship, because
How can you be heard? We never bothered to go and assert your rights also. You're not bothered by very fact that when they gave that letter to all the both parties that you go and establish. She went and established, finished.
Lordship, it is only just few months.
And the thing is that they have a marriage certificate. Becomes much easier for the court also. You didn't go also maybe because you don't have a marriage certificate. It'd be difficult to after you've not cohabited with your husband since 90 something. So
Lordship, in this respect, I rely on one of the ground, that is page 14, ground G.
What does the ground say?
For that the petitioner belongs to the Khasi community and she is governed by the Khasi Hills Autonomous District Khasi Social Custom of Lineage Act 1996, wherein section 2(1) within bracket defines the meaning of legal marriage. In this connection, attention of the Honorable Court is drawn to section 2 clause 1 of the said act, which read as follows and may be perused. Legal marriage means any form of marriage performed, solemnized or recognized under any law for the time being enforced or under the prevailing Khasi custom. Hence, it is submitted that both the petitioner and Carlos Lamin Gang, being the members of the Khasi scheduled tribes, and as such they are governed by the local customs and tradition, and the Khasi society views cohabitation between a man and woman as marriage as per the traditional law. He was there, Lordship. My husband was with me till 2014, Lordship.
Impossible.
Lordship.
See by the own application of this lady. See who. How is it possible?
Lordship, that's why, Lordship, I have filed only when he deserted me, then and only, Lordship. Otherwise, I would have filed my maintenance petition way back, Lordship. When he has deserted me, then and only I filed maintenance application, Lordship.
Where's the maintenance order?
Maintenance order, Lordship. That is, Lordship, page 32, annexure 5. Page 32, annexure 5. Page 32, annexure 5. I'm sorry, Lordship, that is page 29, Lordship. Page 29, annexure 5. The case is posted today for steps. The petitioner is present along with her legal aid counsel and filed Hasira. The learned LEC submitted that the opposite party had expired and the petitioner has stopped receiving maintenance. Further, she could not obtain the copy of the death certificate as it is with the second wife of the opposite parties. Learned LEC submitted that the instant case has become infructuous and prayed to pass necessary orders. In view of the submission of the learned LEC, I am inclined to drop the proceedings of the instant case, Lordship.
What's LEC?
Legal aid counsel, Lordship.
Okay.
Here I was the legal aid counsel, Lordship.
You are
Yes,
you are
yes.
yourself a
Yes,
legal counsel. So this also you're doing free.
Yes, Lordship.
Very good. But yes, Mr. Yubin.
My lord, this is a civil revision petition that come before challenging the order declaring me as a legal wife of my late husband, my lord. Now, my lord has rightly pointed out that there was a claim and counterclaim, my lord, and my claim was on the basis of a valid marriage certificate recognized under the Indian Christian Marriage Act, my lord. And also, my lord, the most importantly is, my lord, in the service record of my late husband, myself and my children, my lord, who are the children of my late husband, my lord, have been all recorded as a beneficiaries, my lord.
Yes.
So, on this basis, my lord, now there is a judgment also, my lord, which says that even if it is let's assume for a moment that the petitioner is a legal wife. Let's assume for a moment. Now, if my name is recorded in the service record of
you'll take precedence.
That will take precedence, my lord. Here, I am equipped with marriage certificate. First of all, the marriage certificate issued by a competent clergy, my lord, under the act, my lord. So, coupled with that, that's been confirmed by an order of the court declaring that. Third thing is that, my lord, my name has already been recorded in the service records, my lord.
That's the only thing that is
my lord.
Yes.
My lord. So, my lord, now only the issue that the only grounds that my friend is challenging, my lord, is that I pled a fraud on the court. Therefore, this order has to be reviewed. This is the only ground that is coming forth, because other natural justice and all this are following off from his first allegations of being playing fraud with the court. The first thing is that there is no question of playing fraud, because number one, in the year 2000, our marriage was solemnized, my lord. He is saying that 2014 till then husband was still so those are, my lord,
that is submissions only.
Yes, my lord, those are. Therefore, my lord, there is, if you see the order which the learned district judge has passed, my lord, there is no ground to fault that judgment, my lord. There's no ground to fault at all, my lord. Now, if he is claiming that, if she is claiming that I have played fraud on the court, then they have to file an application and saying that, see, this person has played a fraud and kindly recall on the basis of not the CRP, my lord, because on the face of the judgment, on the face of the record, my lord, there is no ground to say, and there is no ground made out for a review or revision petition, my lord. My lord, that is, I would like to place the judgment, my lord, which says that the record precedent is we have it, 2008 volume 2 SEC or 236, my lord.
2008?
Oh, I'm sorry, 2008 volume 2 SEC 238, my lord. This is the case of Vidyadhari and others. We have there? We don't have? Okay. Where is the printed one? My lord, I will just, for the benefit of I thought that we have given a code. Okay, my lord, I'll just read for the benefit of the court, paragraph 13. Slowly I'll read, my lord.
Read it.
Paragraph 13, it says that this court in Rameshwari Devi case has held that even if a government servant had contracted second marriage during the subsistence of his first marriage, children born out of such second marriage would still be legitimate through the second marriage itself would be void.
That is settled law.
That is settled law, my lord. Now, my lord, if you go further down, it will go to say like that, no doubt that she herself has claimed to be a legal heir, which status she could not claim, but besides that, she had the status of a nominee of Shitaldin. She continued to stay with Shitaldin as his wife for long and was a person of confidence of Shitaldi, who had nominated her for his provident fund, life cover scheme, pension and amount of life insurance and amount of due. Under such circumstances, she was always preferably even to the legally wedded wife like Sukrana Bhai. So here, my lord, Sukrana Bhai purportedly claimed to be the legally wedded wife, but he lived with the second wife, my lord, until he bred his last. And during this time,
you see, for proof of cohabitation, that is
my lord,
sort of the standard that's drawn by courts also. There's no cohabitation. Maybe she died, while he died while he was with her. So those things, all those things circumstantially that point towards a valid marriage. So that's taken consideration, not to deprive a person who might be destitute. Then yes, fine. But this case is different. The case is different that there was a claim counter claim before the authorities. They said go to the court. Now they have not gone. You could have taken legal aid counsel. Why you could have done that time?
Lordship.
So anyway, but the thing is that it's yours an outside claim.
Lordship.
So what? And your child's a major also.
Major.
So.
Lordship, here, Lordship, only the issue is who is the legal wife, Lordship. So
exactly, but you didn't seek review of this. Now, the only thing you expect by this court, that where's your prayer? To set aside this order and remand this matter back for fresh consideration. Are you asking to quash the order and declare you as legally wedded wife from this court? We're starting evidence now. That's not permissible. I understand your difficulty, maybe to marry, but then it's an uphill task. And they have all the, we have to go in accordance with law. Yes.
Lordship, I may be clarified to some points. Lordship has raised doubts about when my husband has deserted. Lordship, kindly come to page 8 of my... No, Lordship, it is there, Lordship. He has deserted me in the year 2014. I will substantiate, Lordship.
Then how does he had children with the other wife in 1998? So 98 to 2014 he was cohabiting with both wives?
Probably, Lordship. Lordship, kindly come to page 8, Lordship.
I have an instruction, my lord, it's not on record, but she already conceived another child from another man. She is already living with another man, and they are living in Nongra.
This is very unfortunate submission, Lordship. This is very unfortunate submission.
I have the instruction to say that, my lord.
So you file an affidavit to this effect. This is very unfortunate submission. You file an affidavit to this
whoever they
effect.
prefer, that's nothing. But the only thing is that we're coming to your rights vis-a-vis the deceased person and the
Lordship, I will substantiate that my husband was with me till 2014, Lordship. That is page 8, paragraph 4, Lordship, of my petition.
Yes.
I may be allowed to read that the late husband of...
When was the loan taken?
Sorry, yes, Lordship.
When was the loan taken? 2014?
No, Lordship, the amount was liquidated on 2007 to 2015. Otherwise, you would have objected, Lordship, if he has deserted me or I do not have any relation with him, Lordship. Besides, Lordship, during his when he was seriously ill, Lordship, I have accompanied him to Guwahati for his treatment, Lordship. That also I have enclosed the certificate which was issued by the hospital, Lordship.
Very difficult. Very difficult. You file under what? Order 6. What under what provision you file? This is application under?
Under order.
Order 6, yes. Yes, what to do?
Even, Lordship, my voter ID card, my bank passbook, everything.
The most relevant papers, we see, we just honestly taking long time. But since we have time, the only thing, the most important things are with them. So, you try to compromise them to give you some money.
That is what we say.
We have tried to compromise.
But you refuse.
They are suggesting that they will pay only 50,000.
They take 50,000. Now from the court, you won't get 50 paisa also.
Yes.
What will you do? It's 50,000 or you get 00 from here only. Because no materials are there to interfere with the order also. And even if you go like exceed jurisdiction and examine the marriage certificates there with the respondent, plus he's the nominee, what kind of court will overrule those things?
I will satisfy Lordship to pertaining to the issue of marriage certificate and the nominee, Lordship.
We're not a trial court here.
No, Lordship, I'm not. I'm
just orders, yes, okay.
Lordship, I may be allowed to place some decision regarding the marriage certificate and the nomination, Lordship. I may be allowed, Lordship, because Lordship, as per section. Section 4 and 5 of the Indian Christian Marriage Act 1872. Section 4 is saying that every marriage between persons, Lordship, here is saying that, Lordship, section 4, every marriage between persons, one or both of whom is or are a Christian or Christians shall be solemnized in accordance with the provisions of the next following section, and any such marriage solemnized otherwise than in accordance with such provisions shall be void. So, Lordship, if two parties are Christians and if they register their marriage under the Special Marriage Act, they have not solemnized their marriage under the Christian Marriage Act, will their marriage be called as void, Lordship?
Why should it be void?
So Lordship, this provisions of section 4 is directly, Lordship. It's not mandatory, Lordship.
You'll get 0, Mr. Deb, I'm telling you. I understand you're trying very hard and you're doing a good job, but take down will disposal of. Since you won't take 50,000 also, you won't get.
Lordship, I may take instruction.
You take 50,000.
I may be allowed to take.
Now they take 5. We'll give you only 5,000, I think, after the hearing's over. Otherwise, nothing. He's once a nominee and marriage.
Nominee is also
whatever miscase, it is just to prove veracity of the marriage certificate.
Lordship.
And it's been found to be valid. Correct.
Lordship.
And even then, the nominee is the respondent. So where do you stand?
So, Lordship, for nominee is saying that the Honorable Apex Court has stated that the nominee are only the custodian. It doesn't confer any legal heirship on the nominee, Lordship.
It confers right.
Yes, Lordship.
First right
they are the
on
custodian.
the person to the estate, whatever to the benefits of service benefit, terminal benefits of the deceased employee. That's it.
They are the custodian, Lordship. They are not entitled to.
Or the custodian will keep it for someone else.
So, Lordship, that's why, Lordship, I am before you, Lordship.
We'll give you 1 week's time, but you cannot improve your case with it. I'm sorry. I understand you're very valiantly fighting for your client. Maybe she was married, no doubt. But then, on the materials, court can't do anything. We can't start imagining things that, this thing happened, that thing happened, and can't you relieve? Yes.
20?
Yes, after 1 week.
2 weeks, Lordship.
You take instruction, otherwise you take something they're offering you.
Sure.
Otherwise.
What is, Lordship?
Obliged.
Yes.
This is a pension matter also as well. Take some time.
Entitlements. No, you're supposed to obtain clarifications as what is he entitled to.
But the 60% criteria, what is the implication of that? That's the only question.
Yes.
Lordship will kindly recollect, Lordship, that this very court's division bench had dealt with the matter, Lordship, and disability pension is granted to somebody who was invalidated only with 20%. Disability.
That we've seen last time. You've already shown it to the court.
Lordship. Next week, I'll come.
Just give him something.
Lordship.
He was out of service 89.
Lordship. Delay is only factor.
Of course. Yes, Dr. M. Bozika He might be just given some token amount, if that can be done. Has been done the other case, which is that Mr. Gautam's case, I think, from Nepal.
Sangresu's case.
Oh, Mr. Changresu's case. Yes. There's some, some kind of settlements given, even notwithstanding the delay. Just after 2 weeks, the request of Dr. Mosika to enable to obtain positive instructions. Yes.
22.
Hello, the MECL matters. Yes.
My lord, this matter is listed for hearing, but I have filed a miss case also, my lord.
Why?
My lord has closed my right to file the rejoinder, my lord.
Yes.
This miss case, my lord, I am seeking, my lord.
Recall the order. Why? It's very important to file. Very important to file rejoinder.
My lord, rejoinder will
change
the
direction of the case.
My lord, the direction of the case is already set. It cannot be changed in any manner. But sometimes, my lord, for the satisfaction of the beneficiary, my lord, we need to.
Yes,
so my lord will kindly accommodate me, allow me to file the rejoinder.
This case number 187 of 2023 in WPC number 468 2023.
We'll file it by Monday, my lord.
It's an application for recall of order dated 3/8/2023, whereby the right of the petitioner to file the rejoinder was closed up. Seen the grounds made out in the application for non-final rejoinder stop. If the good grounds shown, the order dated 3/8/2020 is recalled, and the petitioner to file the rejoinder to the affidavit filed by the respondents within a period of 2 weeks.
I'll file it by Monday.
A period of 1 week from today. Yes.
Let the matter come up after 3 weeks for hearing, my lord.
The matter is a matter for hearing after final rejoinder in 3 weeks. Yes.
Oblige.
Where are the parties?
Item number 4, supplementary list.
Mr. Paul's not here.
He's out of station, my lord. Mr. Thapa is here, my lord.
He'll be there because we have to. Your allegations are that, you are not heard. Correct.
Yes.
So it is nothing. It's just to see whether submissions are correct or not. Not that we're taking it as part of evidence or taking. So we will convene at, I think, 12:20 at in the conference room.
Okay.
Counsels for the parties. Right? Yeah.
Much of
You know the conference room? The BC room, yes. We'll get that CD plate there. Yes. Yes.